Good morning, everybody. This is
Good morning, Polly.
good morning. It's awesome to be here on this webinar discussing parentage, reproductive rights, and what Massachusetts can do to move us forward. I am Polly Crozier. My pronouns are she, her. I'm the Director of Family Advocacy at GLBTQ Legal Advocates and Defenders. And on behalf of the Massachusetts Parentage Coalition, I just want to thank you for joining us today for this incredibly important conversation. We know it's an incredibly busy time in the legislature and beyond, particularly for the House. So we are recording this webinar for all registrants for the future. And I just want to say thank you so much to Rep. Kane, one of our lead sponsors of the bill, for being here this morning in this very, very busy time. And I just want to pass it off to her to welcome the crowd.
Thank you, Polly. And thank you, Polly and Kate, for all that you're doing to lead the advocacy for the Parentage Act. It's so appreciative. And we know how much work it has been, and hopefully we're getting close. Thank you all for tuning in today to this very important briefing. And thank you to all the other panelists for all the advocacy work that you're doing as well. I think working together, we're going to get this done this session. I'm very optimistic. And it's not only because of the great advocacy, but it's also because of the timeliness of the conversation and that people have an elevated understanding of really what's at play at the moment, and the risks that come from there. I'm originally from Maine, so I'm always, when I see Maine enact something before we do here in Massachusetts, I get very competitive. We really have a great number of legislators who are really working hard to get this bill out. Really grateful to Chair Day and Judiciary and Chair Eldridge, who have made strong commitments to us to advance this bill, and hopefully we'll see that action very soon. I'm also grateful to the co-filers of this bill. So Rep. Peake and I filed in the House, and Senator Sear, who I see joining us right now, and Senator Tarr have filed in the Senate. We've all worked really well together, along again with Polly and Kate and Arlene, to make sure that this is a bill that rises above all the other important bills that we have here to get done this session. So with that, maybe Polly, would it be okay if I just invite Senator Sear to say welcome and good morning now that he's joined in?
Absolutely.
Good to see you, Senator.
Good morning, Representative, and everyone, and particularly kudos to you for just making some time for this. This is a quieter week in the Senate, but this is a very busy week in the House of Representatives. They're taking up their the FY25 budget. It's sort of the biggest, one of the biggest things that y'all do. And Representative Kane has been extraordinary, not only on this matter, but on a number of LGBTQ equity and public health initiatives, and it makes me feel really good to be here in Massachusetts, partnering with Representative Kane, certainly Representative Peake, Senator Tarr, in my chamber, right? Where, in other states, these may be partisan issues, but here in Massachusetts, they're not. And I think the bipartisan support that we have for the Mass Parentage Act is absolutely really essential. And I really sort of chalk this up to, I think there's a bad tension in Massachusetts of maybe resting on our laurels when it comes to crucial policy that relates and is important to LGBTQ people. Certainly, right, we know that parentage does not only affect, our outdated parentage laws does not only affect LGBTQ people and families. It affects a whole range of families, and really in a state where Massachusetts has the highest number of children who are, who are come into this world through either assisted reproduction or IVF. This is sort of long overdue. So we're really eager to get this out of committee and bring it to the floor to a vote. There's been some minor opposition, I think, that we've already worked through on this issue, and really this is crucial, right? LGBTQ families and a number of families are at risk because of our outdated parentage laws. If you talk to our colleague, Representative Jack Patrick Lewis, when he and his husband travel out of state, they always bring the adoption papers and the birth certificates, right? When they travel to another state, which is absurd. I think is something that most families, don't think about. In my own family, my sister's also queer, so it's a twofer. But and my sister and sister-in-law, under outdated parentage laws in Massachusetts, were they traveling, in one of these states, and there's over 20 of them, unfortunately, who at this time are doing everything they can to strip LGBTQ people of equity, of basic rights. God forbid something awful happened to my sister, who's the birth mom. My nephew Kian, who's 5 years old, could be taken away from his other mom. This is just sort of unacceptable, and I think particularly as look, we already have so many families who are created through non-traditional means. Massachusetts just is really behind the eight ball here, and so this is really something we're hoping that we can get done this session. We've done we're doing a full court press. I was on the record over this past weekend to talk about this as well, to really build momentum. So I think we're feeling pretty good, but really I think appreciate your engagement and seeing the partners that we have who are joining you today, from the AG's office, to Reproductive Equity Now, and our whole suite of repro advocates and others who've been working to get us to this stage. So thank you so much for being here. Hannah, you probably need to go sign on to some amendments and get some work done. So let us know. We'll duck off. But really, I guess I'll turn this back over to Polly and Glad, who's been doing so much work around making sure that Michigan does not eat our lunch, and we get Massachusetts back into being at the front of the pack when it comes to protections for LGBTQ people and our families. So just thank everyone for doing what you're doing and helping us get this over the finish line.
Thank you so much.
Thank you so much.
And thank you so much, Rep. Kane. And definitely back to your difficult legislative work ahead. Thank you so much. And really, truly, this bipartisan leadership on this bill, Senator Sear, Representative Kane, Representative Peake, Senator Tarr, and of course, also Representative Khan, who has been a leader on parentage equality as well. Like, we're so grateful for the dream team we have on this bill. And thank you so much for being here this morning. So I'm just going to switch.
And Polly's going to send that clip to Michigan too.
Oh, yeah.
Don't forget Maine.
And Maine. Yeah.
They're eating our lunch. This is embarrassing. I mean,
this is embarrassing. We can't have this.
Chatting, right? There's a little cabal about electeds, and we keep in touch. And my friend in Michigan was like, look what we passed. And my friends in Maine are like, look what we did. And I'm like, I can't believe we're the outlier here. So anyway, thanks so much. Good to see you all.
Thank you.
Take care. Not for much longer. Have no fear. So I just want to turn kind of to talking more about the bill and also about the context nationally and locally. As you know, we're experiencing really aggressive efforts around the country to restrict reproductive freedom, equal rights for LGBTQ people, their families, their children. And this conversation is really going to talk about the intersection of those connected issues. As you know, as has been said this morning, Massachusetts has been a leader on reproductive rights and LGBTQ rights, but unfortunately, our laws protecting that relationship between a parent and a child are over 40 years old. And of course, these statutes being outdated really leave substantial holes in protections for children born through assisted reproduction and surrogacy. We are just about at the 20th anniversary of the Goodridge case, 20th anniversary of marriage equality. Massachusetts led the nation. We're heading to that anniversary on May 17th. But we have to remember we leave children of LGBTQ married families out of the system, unprotected as second-class citizens, and because their families still need to go through so many hurdles and hoops to be protected like all others. The Massachusetts Parentage Act is one of those measures to really make sure that all families formed through assisted reproduction, including IVF, including surrogacy, are legally secure, and particularly protect LGBTQ families both in Massachusetts and also wherever they travel. The Massachusetts Parentage Act Coalition is over 60 organizations and many, many individual families and children. And we're so thrilled to be here on behalf of this bill and to talk a little bit about the reproductive rights intersection. So I'll pass it off to Kate.
Thank you, Polly. So I'm Kate Weldon LeBlanc. I'm the executive director of a nonprofit that has recently been renamed. Now our name is All Paths Family Building. I feel like I always want to say like Prince, formerly known as Resolve New England. And I've been very proud to be the executive director and the co-chair of the Mass Parentage Act Coalition for a while now, and so grateful to all of you for joining us today, and especially to our panelists. So as Polly said, we have seen, unfortunately, nationally, the threats that we're currently dealing with in terms of reproductive justice and LGBTQ rights, and all the ways those intersect, as well as all those ways those intersect with family building and fertility. And this is National Infertility Awareness Week. That's why I'm wearing orange. Today is particularly Wear Orange Day. And so we figured this was really an ideal time to talk about this and put it in the context of Massachusetts. And so our panelists today are going to talk about these threats to reproductive freedom, but also what we can do in Massachusetts to protect children born and families created in a variety of ways. And so that's the part that we love about this. So I also have the honor of briefly introducing our panelists, which I'm happy to do. And we are truly honored and grateful to welcome them today. We were not exaggerating in the invite when we said that these are three of the leaders locally and nationally on today's topic. So we are so thankful. In the interest of time, I am going to briefly introduce them with a wish that I could share their full impressive bios, which we're going to do when we send out the recording. But I'm going to start with Amanda. Amanda Hainsworth is the Senior Legal Advisor and Deputy Chief of Staff to Massachusetts Attorney General and rock star, Andrea Joy Campbell, also a Boston Latin grad. Amanda leads the AG's office strategic initiatives in many key areas that we care about, including but not limited to reproductive and LGBTQ plus rights. If I had to describe Amanda in only 2 words, they'd be legal steward, because she is truly at the forefront of some of the most pressing issues in the Commonwealth. Thank you, Amanda. Karla Torres is the Senior Human Rights Counsel for the National Center for Reproductive Rights. She is responsible for developing and leading the center's work on assisted reproduction, including IVF, surrogacy, and embryo personhood. If I had to describe Karla in 2 words, it would be calm brilliance, because she shares her wisdom so effectively to protect fertility and family building, but with an understated style that is much appreciated, including by me. And last but certainly not least, Rebecca Hart is the president of Reproductive Equity Now, and has dedicated her career to ensuring all people have access to the full spectrum of reproductive health care. Rebecca and her team at REN have secured critical legislative victories to safeguard and expand reproductive freedom in the Commonwealth, including the Reproductive Health Access Law that passed in response to the fall of Roe. If I had to describe Becca in only 2 words, they'd be fierce determination, because she's tireless, trusted, and effective. So that just gives you a sense of who these folks are. Like I said, I wish I could say more, but we're going to start with my friend and colleague, Karla. And I wondered if you could just start by talking about the threats to reproductive health that Polly and I have both touched on. And in particular, if you could talk about the LePage decision in the Alabama Supreme Court, which I know probably most people tuning in are aware of, but I wondered if you could just briefly kind of give us a little landscape on that, and go from there. Thank you, Karla.
Yes, absolutely. Thank you so much, Kate, for that wonderful introduction. So I guess I'll provide all of the sad and enraging news and like updates of this webinar before we move on to more hopeful and exciting work that is being done in Massachusetts. But just sort of level set, I think at the outset, it's important to note that the Dobbs decision in 2022 really marked a cataclysmic retrogression on abortion in the United States that really has resulted in a wave of abortion bans across the country that every single day undermine individuals' rights to life, to equality, to health, to reproductive freedom and autonomy. In 2023, which was the first full session post the Dobbs decision, the center tracked over 500 bills intended to restrict access to abortion. And these included things like trigger bans, gestational bans, so total bans or bans at 6 weeks or bans at 15 weeks. We saw bills aimed at restricting medication abortion, and we also saw bills that would provide funding for what we call anti-abortion centers, or also commonly known as crisis pregnancy centers. Since Dobbs was issued, we've seen 14 states criminalize abortion. The center tracks all of these developments on a map called After Roe Fell that I think is a helpful resource, and we update it in real time if folks are interested in seeing that. And then we also do wrap-ups of legislation that we track throughout the year. And every December or so, we publish it. And I note it because in addition to tracking all of the legislation that we saw with regards to abortion, we also have incorporated legislation that we track on maternal health and on assisted reproduction. So if you're interested in seeing how all of these issues intersect, because they absolutely do, attacks on abortion or reproductive freedom are attacks on IVF access, are attacks on dignified maternal health care access. These are all very much interrelated. And if you wanted to see how we're sort of threading all of the issues and seeing all of the attacks, as well as the major efforts for proactive legislation that we're seeing across the country that in many instances are spearheaded by folks on this call, you can go and read that legislative wrap up. And that's also on our website. I can drop the link in the chat. But to get back to sort of the attacks on reproductive freedom in the country, we're not just seeing it in state legislatures, we're also seeing it at the courts before judges. We have seen the case in Florida that was recently ruled on that in which the court found or allowed for the enforcement of a 15-week ban on abortion that then triggers a 6-week ban on abortion. We are also seeing this at the Supreme Court, the U.S. Supreme Court. Just this morning, we, in fact, it may still be happening, oral arguments on a case brought against Idaho for not providing stabilizing care to patients in emergency rooms, including abortion care. And that's, required of emergency departments under the Emergency Medical Treatment and Labor Act, which is a nearly 40-year-old law that requires hospitals to provide stabilizing care to patients presenting with emergency conditions, including abortion care. All of these attacks are interconnected, and we're seeing them across the country in our legislatures, in the courts, in the public discourse, even though it bears repeating, a majority of Americans support abortion, a majority of Americans likely support access to fertility care and family building medical treatment, and protecting families that are born via this fertility care and assisted reproduction. I'll move to the LePage case. So in addition to seeing attacks on reproductive freedom through the lens of abortion or access to fertility care, we've also for a very long time seen efforts to establish personhood for fetuses and for embryos. And, in many instances, we've been able to fight back. Unfortunately, in February of this year, the Supreme Court of Alabama, the state of Alabama, issued a ruling that essentially recognized that argued that cryopreserved IVF embryos are legal people with legal rights under its wrongful death of a minor statute. And before I jump into the LePage case, just briefly, I want to sort of outline the context in Alabama, because it's a little bit unique, but it also, I think, brings to bear how all of these issues are interconnected. So in 2013, the Alabama Supreme Court ruled that fetuses are children at any gestation under state criminal child abuse laws. Then in 2018, the state constitution was amended to protect, quote, protect the sanctity of unborn life. Then in 2019, Alabama's Human Life Protection Act was enacted, banning abortion at any stage of development. And the only exception was to protect the pregnant person's life if it was seriously endangered. And then in 2023, we saw a total abortion ban being enacted. And then we see the Alabama Supreme Court take it a step further and say that under this protection of the sanctity of unborn life language in its state constitution, remember, that also encompassed extrauterine cryopreserved IVF embryos. And this is, it goes without saying, was a radical ruling. We have not seen another state Supreme Court or any sort of court ruling that finds this the way that the Alabama Supreme Court articulated this, which also, cited to biblical excerpts and, really was a theological exercise in what the state Supreme Court found to be, or thinks to be true about cryopreserved embryos. In the aftermath of that ruling, we saw 3 of the biggest clinics in the state pause their care because they were fearful that if they mishandled or if they discarded embryos at the behest of patients, or if they transferred an embryo that didn't implant, that would be, quote, the death of a minor for the purposes of the wrongful death statute in the state. And this, of course, devastated the many patients in the state who had turned to IVF in order to build their families. And we saw countless of stories from patients who were devastated, who had saved up all of their money, had taken out loans, were really banking on IVF to help them build their families, or who had embryos frozen in the state and all of a sudden were at a loss for what would happen in their fertility journey and in their journey to build their families. So as soon as Alabama happened, a lot of us were concerned that we would see similar rulings or legislative efforts in other states. Fortunately, we've been able to keep those at bay and to really reinforce for legislators across the country that if what they want is to protect access to IVF and ensure that people have access to IVF, the best way to do that is to turn to insurance mandates, which insurance or the out-of-pocket cost of IVF and the lack of insurance coverage is one of the biggest barriers to accessing fertility care for all of us. And so turning to mandates and insurance coverage is really important, as is parentage laws, and making sure that if a state is going to expand access to fertility care, that it also enshrines strong legal protections for families that are born via assisted reproduction.
Thank you so much. That was great. And you're never a downer, but yeah, that was a hard part of the conversation. Those were unprecedented. These are unprecedented times, but thank you.
Sure.
You're
And
next.
Sorry,
Okay.
I just wanted to add one other thing, which is that there's a patchwork of protections in the US with regards to access to fertility care and with regards to parentage. And here I would point people to the Movement Advancement Project's website. They have a map that they also update in real time to really capture where states have strong legal protections for families, and in particular LGBTQ families, and what those protections actually look like. The golden standard for parentage laws is the Uniform Parentage Act, which was enacted back in the 1970s and has been updated through the years to really reflect the changes and the advancements and progressiveness that we've achieved in the last 70 years. Is that 70? Yeah, 50 years, excuse me. And was most recently updated in 2017. And so I just want to point out that, as we see a trend in, yes, the bleak attack on reproductive freedom, but also the progressive efforts that many states are taking to expand access to fertility care and to enshrine strong protections for families born via assisted reproduction, there is a law that we can look to, and there are a lot of efforts underway in Michigan, of course, which is excellent, but also in Massachusetts and many other states. Thanks, Kate.
Yes, and unfortunately, as many of you know, Massachusetts is the last state in New England to make these updates, and so that's why the time is now.
So I'm going to turn it over. Thank you so much, Karla, and turn to Amanda Hainsworth. And I just want to say, first off, Amanda, thanks so much to you and Attorney General Campbell for your incredible, strong support for the Massachusetts Parentage Act and for recognizing that we really have to do the work to protect all children, no matter the circumstances of their birth, including through assisted reproduction and surrogacy. So I'd love for you to just walk us through, can you tell us the goals of this type of legislation of the Massachusetts Parentage Act and a little bit about what it does?
Yeah, sure. Well, first, thank you to you and Kate and the Parentage Coalition for inviting me to participate today, and so appreciative of Senators Sear and Tar and Representatives Peake, Kane, and Kahn for their strong leadership and support of this critically important bill to strengthen families in the Commonwealth. The Attorney General is indeed a strong supporter of the Parentage Act, which is really important in our view for a couple of different reasons and would serve a number of goals. I think at the highest level, our parentage laws in the Commonwealth are woefully out of date. And, we've fallen behind, as has already been noted. Excuse me, I'm a little under the weather. Efforts across the country to ensure that parentage statutes reflect the diversity of modern day families and advances in science. The Parentage Act would remedy that by updating our laws to clarify who can be a parent, how to establish parentage. It would codify parentage precedents from the SJC. It would ensure that children born through assisted reproductive technology have a clear route to establish their legal parentage. It would provide clear standards for establishing parentage through surrogacy and for courts to resolve parentage claims. And it really would achieve equality for LGBTQ families so they can establish their parentage like other families. And it would do all of these things in a way that comports with the Constitution. I think, for us, there are a couple of byproducts of that I think are pretty important. One, I think, is it would result in greater stability and consistency in our probate and family courts, which need clear and uniform standards to apply to ensure predictable and consistent results for families across the Commonwealth. It would bring us in line with the rest of New England and developments across the country to update and modernize parentage statutes to reflect life today, not as it was in the 1980s, which was the last time our parentage statute was updated. And that, modernizing it would mean that it would, reflect the family diversity that we now have in the Commonwealth and those advances in science. And as has already been discussed, it's a really important bill in this particular moment where LGBTQ rights and reproductive rights, including assisted reproductive technology, are under attack across the country. And much like, we've already done, as a leader in marriage equality, as first out of the gate with the nation leading abortion provider protection bill, Shield Law, in the wake of the Dobbs decision, and against the backdrop of the national climate, we really do need to ensure clear paths to parentage for all families, including LGBTQ families and families who rely on assisted reproductive technology. We're not in a position to, I think, lead on this issue as we have in other contexts, but we really do need to act.
Thank you so much, Amanda. Could you just speak, because you are, work for the legal agency in the state, could you just talk a little bit about the constitutional piece, right? Like why it's important to treat children equally and kind of what Obergefell and Pavon kind of means for Massachusetts?
Sure. So, I think it is really important that children of families and parents, families who are, married and reflect the legal status that the states have been afforded to them, have equal access to parentage claims. And I think in states that have enacted parentage protections like the ones reflected in the Parentage Act, have withstand constitutional challenge in every other jurisdiction in the country. Supreme Court has declined to grant cert in cases that have reached the court on these questions. And so I think it is not only, the protections are not only constitutional, but I think when you reflect on the constitutional protections that we have for LGBTQ families, it is really important that we make sure that that LGBTQ families and children in LGBTQ families have equal access to parentage protections.
Thank you.
Thank
Kate,
you
I'm
so
gonna
much.
turn it over to you. Yeah.
And I'm going to turn it over to Rebecca. So Rebecca, we're so grateful that Reproductive Equity Now has been part of the Mass Parentage Act Coalition for a while now. So I just wondered if you would talk a little bit about the other members of the coalition, and then also why Reproductive Equity Now wanted to be part of it.
Yeah, thank you so much, Kate. And I'm going to steal your opener of 2 words to define panelists going forward. That was awesome. So I love being in this conversation today. I think that the diversity of panelists that you see here really reflects the diversity of this very broad coalition. It is made up of individuals, young advocates, families, physician-led organizations, hospitals, legal groups, advocates for children's rights, advocates for groups defending the right of queer and trans people, and of course, fertility and repro equity advocates. And of course, we've got Governor Healy and Attorney General Campbell on our team. So it's a really broad coalition that speaks not just to how popular this legislation is, but really to how many lives it will impact improve, and how vitally important it is that frankly Massachusetts play catch up. It's embarrassing, and I don't use those words lightly, that it has taken us so long to pass a parentage law, and we need to move quickly. So I want to talk a little bit about why parentage specifically is so important in the context of repro rights in Massachusetts. As Karla said, you know, we're living in a post-Dobbs world, and it's critically important that that parentage is seen through a reproductive justice lens. The work of advancing reproductive freedom is inextricably linked to ensuring that LGBTQ people have the freedom to love who they want to love and to start a family with whomever they choose. And I want to be really clear that calculated efforts to strip away gender equality and abortion access are rooted in misogyny and not morality. And there are also calculated efforts to undermine the way many LGBTQ rights that flow from Roe v. Wade's far-reaching right to privacy could be abridged. And we have to be very clear-eyed that all of these attacks are of a piece. The right to privacy underpins not just the right to end a pregnancy, but also the right to sexual choice and the right to marriage and the right to build a family. And so just as states across the country are banning and criminalizing abortion, the same states are restricting the rights of LGBTQ individuals and families. The anti-abortion and the anti-LGBTQ extremist groups are a circle in a Venn diagram, and they're working to erode the rights of non-traditional families. And I just want to say here, it's also not, you know, obviously this impacts LGBTQ families, but we can't forget that non-traditional families to some of the folks in Alabama also include women who have delayed starting a family because they wanted to work. And I just want to be very clear about the fact that it's one type of family that they are trying to help, and it's all types of families that we are trying to help. And that's very clear with the work in parentage. Abortion and IVF are ultimately different sides of the same coin. They are medical procedures that allow people to make deeply, deeply personal decisions about when and whether to become a parent, and to allow individuals the freedom to choose how and when to start a family. So, you know, we've been very clear at REN that reproductive equity has to include the right to have a child when you want to, on your own terms, and to raise that child in a loving and stable environment. But without the Parentage Act, a lot of these kids and families lack these basic legal protections.
Thank you so much. I'm like such a bad moderator because I'm like cheering over here. Could you talk a little bit, Becca, about why parentage is important to you personally?
Yeah. So I am very lucky to be the parent of two beautiful girls who came to us through IVF and gamete donation. IVF gave my wife and me the opportunity to build our family, and ultimately it was the insurance coverage for IVF that we have here in Massachusetts that was our ticket to parenthood. So we're so grateful to the fact that assisted reproduction is accessible in Massachusetts because of that coverage. But to protect our parental rights, each of us had to adopt the child to whom we are not biologically related. That cost well over $5,000 and caused enormous worry and heartache. And I want to situate that very clearly in a social justice lens. We had the money to adopt our own children. A lot of people don't. It is on top of that very offensive and frankly frightening to have to adopt your own child and ask a judge to recognize your parental parental rights. So I think the combination of the resources that you need to adopt your own child, and just the fact that going into the court system, even for me, was not pleasant. It was scary, and I have access to, I'm trained as a lawyer. I have access to lawyers who could represent us, but it is not a fun process, we shouldn't have to jump through hoops to secure the necessary legal protections for our families, just because we're in a same-sex relationship. I just want to harken back to what Senator Sear said, which is so true. I would never even think about crossing state lines without all of our parentage paperwork. It is vitally important that our families be protected, including when we travel, and Massachusetts has an opportunity to really step up here and fix a glaring problem. We can advance equality and legal consistency for all families in Massachusetts, and it's really incumbent on the legislature to act this session to do that.
Thank you so much for sharing your personal perspective on this, because I think it is so important to realize, like, these are not theoretical questions. They're not just legal issues that we're studying from an academic perspective. There's real families behind every topic that we're talking about here. And I agree with you. We're fortunate in Massachusetts that we've been a leader on fertility and family building issues, including coverage for many years, although actually access still, even in Massachusetts, for fertility care is still a big issue and something that we need to address. But we also already are leaders in the percentage per capita of children born through assisted reproduction of any state in the country. I think 5% of our births in Massachusetts are related to assisted reproductive technology, which is higher than any other state in the country and the national average, of course. But then for us to be behind on protecting those children after they're born and not securing them to their parents as early as possible in their life is just a huge gap in our laws. And particularly, I mean, one example too is surrogacy. We have no statutes in Massachusetts related to surrogacy. So we've had to rely on case law to protect those families, and it's just insufficient, and we need to do better. So that is just a couple examples of what the Parentage Act would do. And I did see we already have a question, which I think is a great one that maybe you can start answering, Polly, unless you want to send it off to someone else. But people were asking about, if the Parentage Act passes, how it will impact children and babies that have been born already.
Yes. Well, I think that Becca's personal story really demonstrates what the changes will be for children born to LGBTQ families through assisted reproduction and surrogacy. And one is that it would enshrine in the law more paths to securing your child, right? So because of discrimination, LGBTQ families really need a court decree or a judgment or a voluntary acknowledgement of parentage to demonstrate that legal relationship so that it is secure, right? Not only in Massachusetts, but also wherever you go. And so the Parentage Act would make sure that all children born through assisted reproduction can sign voluntary acknowledgements of parentage in the hospital, right? So just like other families in the hospital at birth, you can voluntarily sign a form without a lawyer and be secured to your child. That means, so that's particularly helpful for married parents, so they would not have to go and adopt their own children. So that's one piece that would change after this law. And then there would also be a court process to adjudicate parentage through assisted reproduction, pre-birth order process, some folks call it, so that you can go to court to get a judgment of parentage if you want a court judgment. And that would be a more straightforward process that does not use the adoption code, right? Because the adoption code doesn't really fit our families. It's what we can use to secure our families, but it doesn't really fit our families because it has a number of requirements that are really burdensome that people have to waive, like a 6-month waiting period, like a home study, criminal record checks. It is in fact a quite onerous and lengthy process. So the bill would make sure that you can go to court and get a judgment under the assisted reproduction statutes. So the difference would be the ability to secure your family closer to birth for less cost and more equally to other children. And for families who haven't yet gone through that process, they certainly would have still be able to do that after the law passes. I don't know if anybody wants to add to that answer. Okay. And one of the things that the coalition will do when this hopefully moves forward is provide know your rights information and support for families to understand how to access the new protections, and also training for folks who are interacting with families.
Yeah, that's been such an important part. And I just know the other New England states, that's been such an important part to make sure we don't just say, okay, the bill passed, good luck, but
Yeah.
to help people implement it. And that work goes on for sure. Because we hear from those states still when people are still confused, which is understandable, and we provide assistance on a daily basis. When you said one thing we're going to do after this passes, I thought you were going to say have a party.
Oh,
We're going
yeah.
to do that too.
Well,
We're going to celebrate too. But yes, we are going to help with the implementation.
well, and that's one of the things about, I mean, obviously we want Massachusetts to move in line with other states, right? But the good news is there's a lot of good models out there for new forms and for educational materials. Like there's a really well-laid template. And again, the Uniform Parentage Act of 2017, which recommends to states to update their parentage laws in this way, on which this bill is based. Like this is a best practice bill for which there's a lot of history in other states. So Massachusetts really has a phenomenal roadmap to follow.
And that's one good thing about not being first. We love to be first, but one good thing about not being first, I always say, is learning from the other states and following, learning from the good and the bad of what's happened in other states. And one of our fellow coalition leaders was writing to us in the chat about that previous question also about how also after the Mass Parentage Act passes, parentage of children born before the MPA would also be less susceptible to challenges that might happen now that wouldn't necessarily happen with the Parentage Act. Because as we said, in the absence of updated statutes, courts are relying on case law. But what families and lawyers are dealing with is huge inconsistency, not just county to county or court to court, but even judge to judge within the same court. And a lot of people, I think that were new to this issue really saw that inefficiency and inconsistency argument in addition to obviously wanting to help families. So we've literally had the courts asking the legislature to act, which has really been unprecedented. Several of their decisions have actually asked for the guidance and clarification through statute from the legislature. So
I'm wondering if I could pop in with a question actually I'm going to throw one to Karla and see if, Karla, could you talk a little bit about the Michigan Family Protection Act and how you see that following as a kind of a follow-on to the Alabama situation and how Michigan really saw that opportunity in that context?
Yes, of course. I mean, I think the Michigan effort, although it happened on its first session, which is unheard of, I think it was galvanized by what we've been seeing post-Dobbs is all of these attacks, concerted attacks, across the entire reproductive rights spectrum, reproductive health, reproductive justice, LGBTQ rights that have been so long and hard fought and won. The effort that we saw in Michigan, I think, was galvanized by some of the fears that were raised by the Alabama Supreme Court ruling on personhood. And to be clear, personhood has been a long-standing effort on behalf of anti-abortion activists. It's just that they, they failed to be honest about what their ultimate goal was. Their ultimate goal has never really been just banning abortion. It's been, as Rebecca was saying, all non-traditional families, everything that they deem as outside of the sort of traditional nuclear family. And so I think advocates and legislators in Michigan and many other states are seeing the need to not only enshrine new protections for that, that help to protect reproductive autonomy, family building, family formation, legal security in that sense, but also to shore up protections that may already be existing in case law or in legislation, so as to further protect folks in their state. I mean, we're also seeing this with interstate shield bills, that sort of are offering protections, so that where states are really looking to enshrine their protections, they can also offer them to people who are not within their state, but who also need access to care. So I think, like I said, Michigan was really exciting because it happened all in one session, and there was so much, like just a wave of support, but it also was a reaction to what was happening in Alabama and what we fear may be happening in other states.
One of I was sitting in the Michigan hearing, what you just said reminded me, I was in the hearing, and an opponent of the bill got up and talked about, was asked a question from a Republican about whether they supported IVF or not. They kind of talked around the issue. And then, of course, the conversation changed to, make it really clear that, in fact, no, there was opposition to IVF, to that again, like as Becca said, like the opposition to abortion, to IVF, to building families through assisted reproduction, even to providing healthcare coverage, to protecting the children. It's all interconnected. And one of the things I thought was so powerful also in that discussion was, there was bipartisan support for those parentage protections in Michigan, because I think one of the things we know post Alabama is how incredibly important it is for folks to build families, and how we want to support that kind of on a really broad bipartisan manner. And anyway, I thought that shift in conversation in Michigan was really, really powerful.
And that's why you saw legislators like doing like a backwards backpedal, like, oh, we didn't mean that. We didn't mean that. But it's like, yes, you did. We've seen your record. You can't pretend that this, or in some cases, I think they don't understand the medical side of things, and they don't understand the impact that it's going to have. But it's also like, they're checking the optics, and they see the diversity of people that have to rely on assisted reproduction to build their family. And then they're thinking, oh no, that's a lot of my constituents. Just kidding. We didn't mean that. So I think we have to be really careful judging what people are saying versus what they're doing. And speaking of doing, I would love to hear anyone's thoughts. Amanda, I'll start with you. What could people listening today, there's legislators, staff, and interested people from our coalition and beyond watching right now. What would you suggest? And then anyone can answer this too. What should they do to help get the MPA across the finish line?
I mean, I think so, supporting the MPA. I think my office remains like very. I think we've had a lot of great conversations with folks on this call and in the legislature about this bill. I think we are very eager to partner on this issue and happy to sort of work through any questions or concerns that folks may have listening to this. Like, feel free to reach out to Ann Landry, who's chief of the Policy Government Affairs Division in my office, or to me, and we're really sort of ready to work together and partner. We do, it is a top legislative priority for the Attorney General, and so we are really eager to get it across the finish line, and we stand at the ready to support legislators considering the bill in any way that would be most helpful.
Thank you so much.
I would just also love to encourage legislators to make their voices heard with leadership. This is a really important bill, and leadership needs to hear from you, and to hear you say that, and to hear that it's a priority to get past this session.
Thank you. Yes.
I guess I would add, as uncomfortable as it is sometimes to share your personal experience with something, I think having people who are directly impacted be at the forefront of explaining to legislators and the community at large why this issue is so important is just really impactful. And so I think centering families is always really important in our work. And when trying to draw a direct line from this bill that, you know, may seem theoretical for some people, and this issue, which may not be on somebody's radar, to your personal experience is really important and helps to move a bill along, I think, sometimes.
Thank you. Polly, anything else you would want to add?
No, I mean, I think these are all incredibly helpful points. I think we're so grateful for the hard work that's happening to move this bill forward, to put this bill and the families and children in the coalition and all the families and children in Massachusetts at the forefront and protect their parentage. So no, grateful to everybody for coming today. And of course, if folks have any questions about the language of the bill, please feel free to reach out to me or to Kate. I know we have really benefited in this process from a really deep bench of phenomenal experts working together on this bill, including the reporter for the Uniform Parentage Act of 2017, Professor Courtney Jocelyn, Professor Doug Nietjame, who's a preeminent family law scholar in the country, Senator Jamie Peterson, who is the majority leader in Washington State, who also helped to draft the UPA 2017, as well as so many practitioners who practice assisted reproductive technology and surrogacy law and the law of parentage in Massachusetts, who are in this core coalition and working so hard to bring Massachusetts in line with other New England states. So, you know, we're here to support your work, and we're grateful for your work in moving this forward.
Yeah. And I know we're very committed to ending before or at noon, but I did just want to share with folks that are on the call that don't know where the bill is now. So the Mass Parentage Act is currently in the Judiciary Committee. We have an extension till April 30th for that committee to act. And as Rep. Kane and others shared, the committee and their staff have been doing incredible work on this complex but important bill. And so we're hopeful and optimistic that that's going to be coming out of Judiciary. And so I know there is, and maybe Aaron or someone can share it in the chat, there's a wonderful tool that we have available to us that enables you to put in your home address into this online system that makes it very quick and easy to send a message to your legislator. If your legislator is on Judiciary, they get a certain message, and if your legislator is not, they get a different message, which is great. And definitely highly recommend you to personalize that note. You know, with, as Rebecca said, a little bit of your, or that Karla said, with your own personal story or why you care about this really lets it stand out from the rest. So I really encourage people to do that. And certainly if you have, as Rebecca said, if you have relationships with leadership, or if you are talking to your own legislators, encourage them to keep elevating this up through both the House and Senate to make sure the leadership knows how critical this is and how wonderful it will be. These are wonderful, beautiful bills to pass, and the families behind each and every one of them are just incredible. So we have to do this, Massachusetts. It's time. So thank you for Aaron shared the link in the chat so people can use that to take action. But also feel free to just call your own legislators as well. Massachusetts, mass.gov, if you go to the legislature, they do have a really cool tool that is called Find Your Legislator. And you can, again, just type in your home address, and then you get the names of both your senator and your rep, and you can click on each of them and get their email addresses. So it's a great feature. Oh my God, Aaron, how are you so fast? Anything I say shows up in the chat. If I say $1 million, will it arrive on my desk? How powerful are you? So I think unless there's any other questions, I think we'll close it there because we are determined always to be on time. But again, I just want to thank this incredible panel so much, and also our coalition members so much. I know many of them are on the call, and then a lot of them don't need to be on it because they live and breathe these issues, but we are so fortunate to be surrounded by them and partnering with them, and certainly with these panelists here today. So this is going to energize Polly and I know that, because as everyone knows, advocacy is the long game a lot of the time. And so you need these moments to just reflect on how fortunate we are to work together and be working on these issues that are so important. So thank you all. And I think we'll end it there unless you want to have the last word, Polly.
Nope. Thanks, everybody. Take care.
Okay, take care. Be well.